She trained her roommate for free, then lost everything: a dog grooming business, a handshake deal, and a roommate who thought she could walk away clean. The two women had met through a shared housing app in the spring: a dog owner with a side hustle and a graduate student looking for affordable rent in the city. Within weeks of moving in together, the dynamic shifted. The dog owner, who had been running a small in-home grooming operation for 3 years, noticed her new roommate had a natural touch with animals. She offered her a deal: help out on weekends, learn the trade, split the tips. The roommate agreed. What followed was 18 months of what the dog owner described as mentorship, what the roommate described as a part-time favor between friends. When the roommate moved out in October, she took an apartment 6 blocks away. By November, she had launched her own mobile dog grooming service. By December, the dog owner had lost 4 of her top clients. She filed suit in civil court seeking $14,200. Her estimated revenue losses, plus the cost of a business attorney who had drafted a non-compete agreement she claimed both parties had signed. The plaintiff's case was tight, at least on paper. She presented the signed non-compete agreement, dated 14 months prior, which prohibited either party from operating a competing grooming business within a 5-mile radius for 2 years following the end of their arrangement. She presented client records showing 4 long-term customers had canceled within 6 weeks of the defendant launching her service. She testified that she had trained the defendant personally, shared her client list for scheduling purposes, and had trusted her completely. "I didn't just teach her how to groom dogs," she told the court. "I taught her everything. My techniques, my pricing, my relationships. She took all of it." The defendant told a different story. She acknowledged signing a document, but testified she had believed it to be a simple liability waiver, something the plaintiff had mentioned casually while handing her a stack of intake forms one afternoon. She had never been given a copy. She denied ever being shown the non-compete specifically or having its terms explained to her. She also pushed back on the revenue loss calculation, noting that 2 of the 4 departed clients had left reviews citing scheduling issues with the plaintiff's business, not a preference for her own. She had built her clientele, she argued, through her own reputation, her own social media presence, and her own hard work. "I didn't steal anything," she said. "I started a business." Then the surveillance footage surfaced. The plaintiff's building had a shared entryway camera, and during discovery, the defendant's attorney requested footage from the day the non-compete was allegedly signed. What the footage showed was unexpected. The plaintiff could be seen at the entryway mailboxes, handing the defendant a folder. The defendant flipped through it briefly, signed something near the back, and handed it back. The entire interaction lasting under 40 seconds. But the timestamp mattered. It was captured at 7:14 in the morning. The defendant had testified she signed documents after a grooming session during a relaxed afternoon when she thought she was signing routine paperwork. The footage showed no grooming equipment, no dogs, and a defendant visibly dressed for class. More critically, the plaintiff's own text messages, subpoenaed from her phone, included a message sent to a friend the evening before reading, going to get her to sign it tomorrow before she's really awake enough to read it. The courtroom went quiet. The judge ruled in favor of the defendant. The non-compete agreement, while technically signed, was found to be unenforceable on grounds of fraudulent inducement. The plaintiff had deliberately obscured the nature of the document and obtained consent under conditions designed to prevent informed agreement. The defendant was awarded $20,900 in legal fees. The plaintiff's $14,200 claim was dismissed entirely. In the months that followed, the defendant's mobile grooming business continued to grow. The plaintiff retained 3 of her original clients and eventually stabilized. Those sources close to the case noted she never fully recovered the revenue she had lost. She did not appeal. The 2 women have not spoken since. There is a version of this story where a mentor genuinely felt betrayed, where she invested in someone, built something together, and watched it walk out the door. That version deserves sympathy, but somewhere between the original handshake and the 7:14 a.m. ambush at the mailboxes, this case stopped being about a broken agreement and started being about a trap, which raises the question the judge never had to answer in court. If you have to trick someone into signing a contract, did you ever really trust them at all?